affirm the testimony you're about to give in the matter now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Okay, have a seat. Please tell the court your role in the DA's office.
Yes, I am a SVU investigator, Monica Moore.
Are you assigned to this team here for the case against Melody Farris?
Yes, ma'am.
Have you been assisting putting the trial exhibits together and speaking with witnesses?
Yes.
Friday, the 18th, did you have the opportunity to speak with Miss Martha Barton?
Yes, I did.
And did you, after that conversation, put together a report and provide that to the defense
Yes.
defense attorneys?
Yes.
And did you have the opportunity to speak with her again today
Yes, ma'am.
to follow up with her? And
Also, the sound of theirs going down. Just speak up a little bit louder.
Yes, sir.
what is it that she told you today?
Today she said that her niece Jennifer has been helping her because of her health issues, but her niece wanted to make sure that the gun was not in the safe, and so over the weekend, her and her niece came over, and they checked the house over. They looked for it, and they went into the safe, and they found that the gun was not there. And that they also found some other items, some bullets that went with the 38 special bullets.
Okay. So the firearm, they looked for it over the weekend, essentially,
Yes.
her and her niece?
Yes.
And they still could not find it?
Correct.
Okay. Was there anything else that she told you that was new information from last Friday?
No, on Friday she did say, she described the box of ammunition as red and white box with a TG and Y sticker on it. She remembers that her late husband bought it probably from that store up in Tennessee.
And that was in your report that you provided on Friday?
Yeah, but no new information after that.
Okay, that's all I have for you. Thank you.
Thank you.
All right. Mr. Weaver, Mr. Ware.
Do you know anything about the manufacturer of the bullets? Does she have that information?
She did not have that information.
That's it.
Did y'all direct her to reading whatever she had with her dealt her?
I have told her to just keep everything there and keep it safe and
All right.
yes.
All right. Anything else from this witness?
No, Your Honor.
All right. All right. You sit down. Thank you. All right. Anything else from the state on this issue?
I don't believe so, Judge.
All right. Argument.
We're asking the court to exclude.
I expected more.
John, there's got to pull
Do you have a compelling reason? You have a compelling reason why I should exclude?
And honestly, I don't think you can exclude it right now. You want to?
Unless you argue about it. You already told me.
Yeah, as we all know, normally when you violate the sequestration rule, typically what the court ends up having to do is just giving a curative instruction to the jury at the end that it goes to the weight, not the admissibility of the person's violation. It's obvious from the audio recording that she did violate your court order, that she's not supposed to be watching it. My assumptions would be is that she has watched the entirety of the trial. Otherwise, she wouldn't know when Rusty was testifying, considering he was here, from my understanding, the entire week of last week and didn't even know when he was going to be called. He was essentially just at a hotel on standby to be available at any point in time. Under the case that I found this morning, it's State versus Brett Brown, and it is 354 Georgia App 493, the 2020 case. States that the court actually does have another option. Instead of just giving the curative instruction, it says that where counsel or the witness violates the rule intentionally, the court may strike testimony already given or disallow further testimony. The trial court's denial of a mistrial for violation of the sequestration rule is a matter of discretion and reversible only on a showing of prejudice. What ended up happening in the Brown case was there was a whole issue of whether or not the rule had even been violated at all, because it had something to do with two witnesses overhearing the judge behind closed doors. but that was actually never proven, and the court just ended up coming in and saying, I'm declaring a mistrial at this point, of which nobody essentially was requesting. Obviously, the defense was on board with it at that point, but the mistrial was overturned. The court, in making a statement that it is actually restrictable, was quoting a U.S. I think it's a Fifth Circuit case, Ferdin versus Land Sea Services, which is a 1993 case out of the Fifth Circuit. As discussed, and in that case it said there is no evidence showing that either the defense witnesses would have changed their testimony to match other witnesses. So it seemed like when you look at both of them together, well, actually, let me go into that part. So that was the Fifth Circuit case. The Brown case went on to state, instead, the trial court should have chosen an intermediate option, such as allowing cross-examination of the witnesses regarding the possible violation, and instructing the jury that a violation of the rule should be considered in evaluating their credibility. So that is that.
Standard.
Is the way Millich
He's interpreted out of the Brown case.
is taking it out of the Brown case is that under the pre-2013 statute, the witness could not be disqualified for testifying as a result of a violation of the sequestration order. The new evidence code, although the sanction is rarely used, the trial court may treat a violation of the sequestration rule by citing the guilty party for contempt, allowing opposing counsel to cross-examine the witness as to the nature of the violation, or 3, striking the testimony already given or disallowing further testimony as the rule has been intentionally violated and actual prejudice results. I don't think there's any doubt that we would be prejudiced by this, considering we got this evidence on Friday. There's also another witness that she names in her recording, being her nephew, that he's out of state. We might need to subpoena him, but we're in the middle of the trial now, and this has now just become an issue, even though Ms. Barton has been interviewed now by law enforcement on 2 separate occasions. And the court can clearly hear from her interview, she actually does not come up with this new theory of the gun on her own. She said that the man on court TV, the one wearing the headset, said that's where she got the gun. And that's where she got the idea from. So her testimony between the 2 interviews has completely changed. She's never, and she freely admits that she's never told anyone about this gun being missing, even though she's known it's been missing for the past 5 years. So the state wants to bring her down here, put her on the stand, say Melody stole the gun, even though there's absolutely 0 evidence of that. And in fact, if the court allows it, in her other interview, we're going to show where she was talking to Detective Hayes and Detective Pope, talking about, at length, about some boy who lived next door and was helping her husband and had broken into their house. So I think this, if there ever was a sequestration rule violation that needed to be excluded, this would be it. But I think, in all fairness, I think the court and Ms. Farris's counsel will have to voir dire Ms. Barton to see what all she is going to say, because obviously that small audio recording is not all of it, to get to the bottom, especially of how she knew when Rusty was testifying, how much of the trial she has watched. Because my belief would be that she's watched the entire thing. She watched Scott's testimony, because there's actually some conversation in there about Scott and Chris as well that the court heard. So for that, we would ask the court to exclude Ms. Barton's testimony.
All right, Stokes.
Thank you, Your Honor. Counsel, the issue is whether or not there's been a violation to the degree that she cannot testify. Judge, the first thing I want to cite to the court is OCGA section 1716.10, and that's the code section that says both parties can rely on materials and information furnished in the discovery, so both sides don't have to turn over the same thing. 1716.10 also says that either party may call as a witness any person listed on either the prosecuting attorney or the defendant's witness list. We have listed her several times on witness lists, I believe, and also information going to the defense. We kind of kept her, we did not subpoena her, we kind of kept her, we talked to her before trial, and I think we actually talked about that if we needed her, we could do Zoom or something along those lines. So she was not under subpoena for us. I'm assuming, and I'll let the defense say if otherwise, that she was under subpoena for the defense. If she was not under subpoena for the defense or the state, then she's technically not in violation of the rule of sequestration. And I know Judge, when we argue the law, sometimes we have to argue the technicalities and the precision of it. And so I think she would not be in violation of the rule. That being said, I don't think.
And
No, we
y'all had her on witness list, but had not.
right, and they had her on
subpoenaed
her witness list.
Y'all had her on call, I expect, and
Yeah.
talked to her.
And we talked informally that if we needed her, we would agree by Zoom. But Judge, I think, so she's not in violation of the rule. The second argument is that,
So there's the issue of one, it's new evidence that hadn't previously been disclosed. Then there's whether or not there's sequestration issue.
yes.
All right.
The second statutory law, I'm going to get some decisional law in a second, but OCGA section 1716.4c, 1716.4c, and that is the code section that deals with newly discovered evidence during trial. We actually have a code section on it. It says, if prior to or during trial, a party discovers additional evidence or material previously requested or ordered which is subject to discovery, and it goes on to say, such party shall promptly notify the other party of the existence. Judge, as soon as we found out on Friday, you may have noticed that we were sitting here in court, and we let them know and told the court we had some newly. We went out and discussed it, gave them the information, gave them the recording, and we've been nothing but candid with them and prompt with them. So I don't think it's any violation whatsoever. And then there's several cases that talk about Williams v. State, 261 Georgia App 410, 2003. It cites newly discovered evidence is not in violation of the 10-day discovery deadline because it is newly discovered. Dixon v. State, 252 Georgia App 385, 2001 says no violation because the evidence was newly discovered and was revealed as soon as practicable after its discovery. In fact, the court in our system, as Your Honor knows, State v. Roberts, 247 Georgia 456, a 1981 case. The court, outside of all this newly discovered evidence, even if it was not newly discovered, that is the case, the Roberts case, they reopened the evidence during jury deliberations at the request of the jury. So the court has the ability to reopen evidence at any time and has that much discretion to do it. But when it comes to newly discovered evidence, it's a different rule, and there's been no violation whatsoever of that. And Mahogany, M-A-H-O-G-A-N-Y v. State, 366 Georgia App 750, 2023 case. So under the new rules of evidence, and it literally says, further, a violation of the sequestration rule affects only the weight and credibility of the witness's testimony, not its admissibility. That's Mahogany v. State, 2023 case. And then Park v. State, 314 Georgia 733, a 2022 case. It says, Park holds this. The Supreme Court stated, a party's remedy for a violation of the rule is to request the trial court to charge the jury that the violation should be considered in determining the weight and credit to be given the testimony of the witness. When you look at this, I think there is no technical violation because they were not under subpoena, but in all candor to the court, she was a witness that could have been called by us. I do not think there's a violation that requires the court to charge the jury. I understand if the court charges the jury, there's nothing in this case to prevent her from testifying. And I know defense counsel has a job to do, and I know that this is evidence that should concern them, but I do not think they're telling the court that there's bad faith on part of the state. And the only way to cite counsel for the witness would be showing that there's some type of contemptible conduct by the party. And I can tell the court that that's not been done in this case. So I think they haven't. I think the court has great latitude and has, in fact, great discretion without it being newly discovered. But because it is newly discovered and has come in during trial, I ask the court to allow it.
Anything else?
Yeah, just to respond. In terms of it being newly discovered evidence, it's admissible. I mean, we're not really arguing that. We're arguing more the sequestration of it. If the court does end up allowing, what we're also going to be asking for is not for you to just charge the jury at the end, but prior to her testimony, state that, she was, you can fashion it however you want, but, something along the lines of, she was a potential witness, witnesses aren't supposed to be listening to other witnesses' testimony, and it's going to be her testimony that she listened to other people. So that can go, to her credibility, or however the court wants to word that.
All right, and what y'all's plan is to have her here Thursday morning?
Plan to have her here, I think Wednesday evening, and have her here Thursday morning.
Right, Thursday morning for testimony.
And we'll be glad to make her available to
Yeah,
the
I'd say I give y'all a chance to talk to her. Maybe we do that. I'll think about that.
We could have her as soon as 8 o'clock on it.
Yeah, that might be the.
Thursday morning.
Yeah, I might have y'all.
I think the proper procedure is for we have to do it.
Well, I'd let y'all talk to her, and then if we probably need to.
They would need-
May need to do the same thing with her prior to the jury with the evidence and let her testify as to what the evidence would be.
Was it motion to eliminate?
Yeah. And then, if y'all want to present me a proposed charge, I'd consider it, although I may not. I'll look at that. But y'all definitely can cross her about all that, and that she was a potential witness, and then whatever this other issue you said about whether or not someone else potentially took it, that's also something you could look in, question on. But I think based upon everything that's been presented, I'm going to allow it. I'll consider some sort of limiting instruction if y'all want to put one together and let me look at it. I'll consider that, and we'll talk about that more on Thursday. We could probably have the jurors report a little bit later on Thursday morning, give y'all a chance to talk to them, whatever testimony is going to be on the record prior to bringing the jurors in, go over anything else we need to discuss before we present that evidence, and then go from there, although and then we have the afternoon plan at the moment. All right, anything else?
So, well, we have one more issue.
Yeah. I provided, sort of to pick up where we left off on Friday, I provided
Right.
both the defense and the court sort of a rundown of the digital evidence within Ms. Harris's presentation. I broke it down by, I think, the two main issues that the defense has, which is essentially what's titled geofence, but is the Google location services. And then the second portion is the Apple Health activity. I think those were really the two issues that the defense had with the presentation. I outlined several cases on the memo that used Google location services. Ultimately, I guess to clarify, which I think was helpful even with me going through stuff, was the word geofence is actually the way that law enforcement provides the information to Google to obtain their location services. Geofence is not different than their actual location services on their phones and their apps. All it is closing it off to a certain location and a time frame. That's why it's called geofence. But ultimately, the Google location services use the same technology that has been around for a while. So GPS, cell site location, and also Wi-Fi. And all of those have been admitted in trials for a while. And I just cited some cases that specifically discussed the Google location services and some geofence warrants. Most of the cases, when they come up are in a framework of a Fourth Amendment issue, a motion to suppress issue. There weren't a ton of cases outlining the reliability of it. However, it's 1C, the amicus brief by Google. Google filed an amicus brief in a case that I think was very helpful. It considered, they referenced Carpenter, they referenced all of these cases that are a bit more specific to the Fourth Amendment, but in that amicus, they discuss how it works and why it's reliable, and that it really just uses the same technology that we have been using in our phones and in our cars and so forth. And it describes that kind of when you pull up Google Maps, shows your location in a blue dot, and then if it's not as certain of the exact location, you'll see like kind of a blue circled hue around the dot, and so once your connection gets better, the hue goes away and you see your location. And so it describes that and why it has, when you get a return for the Google location services, it has that radius, and that is the certainty of the actual location of that device. And so I'll move on to the Apple Health activity. That is a little bit more novel of a case, of technology, but I did find a 702 analysis in a case. And so I cited that is United States versus Riego. It's a 2022 case. And it was a circuit court. It was not an appellate court, but it applied the 702 analysis for an expert witness. And so the court held in that case, and you can read it, I quoted the case there, Judge, that the defendant was arguing that the testimony is unreliable because the witness was unsure of when and who at the FBI monitored and validated the UFED system. That's to celebrate. Basically, they did what we did here, Judge. They pulled the activity information from the Celebrate extraction, from the cell phone extraction, which is what we did. And then they had a presentation through a digital forensics expert. And they basically just validated the monitored and validated the UFED system, which was Celebrate, and was unsure about how the application that counted the steps worked. But in other words, apart from knowing that the FBI monitors the system to ensure it's working properly, French did not know whether the system was working accurately on the day he used it to analyze the data from the defendant's phone. Nevertheless, this point affects the weight of the testimony rather than admissibility and can be brought out on cross-examination. It does not render the opinion unreliable. Regarding the health application, French, the witness, did not know the specifics about the operation of the application, but his intended testimony is solely regarding the technical knowledge and data that was pulled off the application from the UFED and Celebrate system. To the extent the inner workings of the health application are relevant, such points can be brought out on cross. So essentially, it's the same role as Ms. Harris would. She would just be communicating the data to the jury in an understandable manner. So,
All right. One of the things I thought about over the weekend, in the middle of the night when I think of things like that, we talked about, I brought up Toxilizer, and then over the weekend I thought about an Alka sensor. Now, we all know the Alka sensor spits out a number. The Alka sensor being a roadside personal breath test device. The number is not admissible in court because the device, even though it spits out a number, is a scientific device and is not inherently reliable. It's not tested, it's not calibrated, it's a portable breath test that, because it's floating around somewhere in the car of the police officer, is subject to variables. And And that's even a device that, is approved for use on the side of the road. And so again, I don't know. We all think we know how it works. We don't really know how it works. I have a better idea maybe than others, but I still don't know how it works. It still goes through Apple's filter and their proprietary information. And so I still think I need to hear more evidence if y'all are wanting to get that data presented to the jury. I might, in thinking about it in that term, comparing it to Alka-Sensor, I might let the witness say that based upon review of the data that was collected, that there was some activity. And that might be, that's better than saying no activity, but I'm still not 100% about that yet. But
sure, and to that point, Judge, and I can proffer this, the testimony about her activity is pretty general. It would be, she had more activity on this night than a year's worth of, and it was an outlier. Right. We're not getting into sort of like, well, she climbed this many flights, so that means she went up and down the stairs that many times. It's not that specific. It was just an outlier.
Your report does have that, so that's probably where
Okay, so the presentation is just the outlier graph.
Right.
So to the point of what would she be presenting in her presentation, it is a very general outlier scenario, sort of like the phone calls with Rusty that we were able to point out. Well, Ms. Harris was able to point out, they didn't speak at this time ever. It's sort of the same concept, just statistically speaking, comparing her own activity with her own activity.
I think that is probably more in line with what would be appropriate without going to specific number of steps and specific number of flights and that kind of stuff. But again, I still, if you got, I know you're looking and still trying to find more information, and I'm willing to, let y'all keep plugging away at it.
Can I clarify with the court, or have the court clarify?
The Google stuff I'm fine with.
Okay.
I think that's,
okay.
Or I think that is certain, and it gives specific, it is submitting and pinging back a specific, latitude, longitude point, and then has a variable around it. And so that, shows the margin of error, if you will.
Sure.
So I think that is appropriate, and I believe that has reached a level of scientific certainty that is appropriate to be presented in court.
Okay. And can I just have the court clarify? So the data itself within the phone, within the extraction, the phone that gave us the data with which Ms. Harris is providing to the jury, that part is stipulated to. So I guess I'm not sure what the court is looking for when it comes to the data itself, as far as the functionality of it.
Well, y'all, whatever you think you can get to convince me. But
I do have, I guess my second question would be, if I have that information with Ms. Harris found a study that was done, she is not comfortable testifying about that study.
Right.
Okay.
That's part of the problem is we don't have someone who can testify to me as
right.
to its scientific reliability.
Right, which could definitely be a subject for cross, and I understand that. Is that something that the court is interested in, that type of article?
The more you can give me, the better
okay.
it is, but I don't, like I said, I don't think that there has been a case that's really utilized it. Part of it depends on what you're trying to do.
Sure.
If you're if your ultimate, what you're trying to get in is that she was on her phone and she's walking around, I think that's okay. I think
sure. So
it's when you want to say she walked half a mile or she went up and down 12 flights of stairs.
I can tell you.
Slides in their presentation.
Right, correct.
Well,
So
I believe there's one side that provides the distance that the phone provides.
Right.
The testimony we obviously have to provide them the data that we got, right? So that would be that.
That would be kind of like,
But
so,
what-
similar to the Alka sensor. So the officer on the stand knows what the number is, but can't testify to the number.
Unless it's open,
So-
the door's open.
Correct.
Sure. So Ms. Harris, ultimately, that number, whatever the number says it is, would hold a year's worth of her activity from just 1 hour, 11 p.m. to 12 a.m. every single day. There are only 3 times, right, that
That she is
Level of
more active
activity.
on that day than she was on that day.
exactly. And
Right.
so that is essentially the purpose of pulling the number. So if the court is more comfortable with us leaving the number out and just stating the outlier dates, I mean, we're happy to do that and carve
I
it
think-
out to the court's comfortable.
I think that is something that I think your witness could articulate that.
Sure.
But I'll still give y'all a chance, but, I'll still let you give me some more information and give y'all a chance to revisit it before we get to it.
Yeah, we'll get it.
If you could, we have a copy of the case we'd like to present to the court. That would be Albright v. the state, 354 Georgia Appellate 538. That would be Albright versus the state, 354 Georgia Appellate 538. That's a 2020 case. And it kind of actually is the only thing. Most of the cases that Ms. Frankish has noted in her memorandum, and everyone knows Ms. Frankish is very diligent with her legal research, but they're all circuit court cases in federal court from all over the United States, but not really local to the state of Georgia, maybe the Trump case to some degree. And then a number of these cases on Apple activity
I don't think that was ever testified to or admitted from.
Oh, I know. It's just.
Yeah, no. I mean, it
it's
was
just
brought up. But I don't think it ever.
Yeah.
It was brought up. I don't think it was ever addressed by the court. I don't think the court
Sure.
ever heard that evidence. And it's on appeal, and I don't think that evidence was ever presented. But that was also a totally separate sideshow issue, not having anything to do with the criminal case and the actual evidence against the defendant that was pending. So I mean, I know you're arguing against it, but I'm also, that's the reason why it might not be.
Sure.
No.
And then moving on to the Apple Health activity, this just, South Carolina versus Murdaugh, and all these cases that aren't really, there's no cites for these cases, and it's not found in science. That's the point. Even within her own research, it becomes very clear. And I have to disagree. I believe the issue on Google is not a found in science either, if you look at the cases that they cite to. And I do have, this Albright case kind of discusses PinLink. And ultimately, the Court of Appeals can't get anywhere because the primary issue in this case was discussing ineffective assistance of counsel primarily. They can't get past that. But the court did limit the use of PinLink in that case. And so therefore, after the inquiry that this court was taking, I think it should take under consideration what the Court of Appeals has had to say regarding PinLink.
Yeah. Well, kind of going back to what we talked about earlier today, you presented the CPAP data. Using that as another analogy, had you tried to present evidence of some medical issue based upon that data, I would not have allowed that so using that same, because that wasn't reliable source would be my concern there. But the activity, I think, is a different issue, and that it was being used, and it was being used on or about these times. Now, if you tried to say it was specifically being used at this time on this day, that may be a different issue. But the fact that it was generally being used overnight on those days, and there was activity every day or every evening until the night that it wasn't used, I think that's an appropriate use of that data. So I guess in that regard, I'm probably using a 403 limitation on it, but it's a very interesting issue, and very right, and I think it's still evolving, and so y'all keep looking, and we'll keep talking about it.
And just for Mr. Weaver's argument, he talked about different cases and circuit cases. Under 24.104A, the court is not bound by the rules of evidence, and then under 24.7702F, for the Daubert standard, we are
Right.
specifically to look at federal courts.
Right.
Is the court fine with us? If we do, we'll copy the defense, of course. If we come up with some studies, maybe some.
Everything that y'all can give me, I'll happily look at it.
All right, thank you, Your
Thank
Honor.
you, Judge.
All right, anything else we can take up?
I don't believe so.
Oh, one thing, I'll probably be late tomorrow. John Luke will be here, but I'm going to be at the office working with our staff members on some of our cases.
Okay, that's fine. All right, we'll be in recess till the morning.